application in the matter of LzLabs and others and
Yes, good morning. It's nice to see so many people come to assist me with my questions. Let's hope you'll all be useful. Mrs. Stewart, I sent an email yesterday just indicating what I hope to gain from this hearing. But just so that everybody is aware, obviously as the Lord Justice concerned with appeals from the TCC, I saw this, I think at the end of May, would it have been? Yes, I think so. And realised that the application was wide in scope and detailed. So before reading anything, I sought today's hearing in order to have a fixed point so that by the time that it was far enough in advance for me to be able to do the reading, and I hoped to be joined by another Lord Justice of Appeal, which of course I have been, so to enable us to do the reading, but far enough away from the 16th of July to allow us time to reflect before producing our order on the application for permission to appeal. So that's effectively the reason that the 20th of June was chosen by me, no other magic other than that. And I thought that was far enough in advance to give proper notice to you and the teams so that at least some of you would be able to be here. So that's that's why we are here. My Lord and I have done the reading, and I have some questions on some of the substance, which I shall be, which I shall ask in a moment, going through them, and then there's the question of this expedition and stay, although of course I appreciate those are largely parasitic upon what we do on the application for permission. And so that everybody is aware, we will not be giving the answer today. As I say, I chose the 20th of June so that it was far enough away from the 16th of July to allow us to have more, to allow us to reflect on what's said today and to complete the reading and to produce what will have to be a detailed, reasoned order. And at the moment, certainly on my part, I'm in court all next week. So the result will be circulated at some point in the week that starts Monday, the 4th of July.
Thank you, Lord.
So that's I hope that's helpful. That's the proposed timetable, and subject to being hit by a bus, I pretty much guarantee that I will be able to comply with that timetable. So, Mrs. Stewart, I don't know if there's anything you want to say in response to that, or anything by way of introduction, because if not, I'll ask some of the questions, but I don't know if there's anything else.
Should I just give appearances? My Lord, yeah. I appear today with Messrs. Ogden, Riordan and MacDonald, and my learned friends, Mr. Saunders.
Oh, the slip's not, oh, the slip's defective. Yeah.
And my learned friends, Mr. Saunders, King's Counsel, Mr. Hobson, King's Counsel, and Mr. Taylor, appear for the respondents.
Thank you.
So far as the order of today is concerned, the message I certainly received and understood was questions only in relation to permission to appeal. So I'm not going to be making general observations about that, and I won't make any observations unless they're pertinent to questions which you ask in relation to permission to appeal. The only matter which your lordship didn't mention, there's obviously the question of stay and the question of expedition, which your lordship referred to, you will have seen that there are also two additional applications. They only go to expedition. One is in relation to Miss Scott's witness statement, which was served on the 13th, that is a week ago, and the other is that of Miss Vernon, which was served yesterday.
Yeah.
I don't oppose Miss Vernon's. I understand from Mr. Saunders that he doesn't oppose Miss Scott's. I suggest that I deal with the relevance of them when it comes to the questions of expedition, if that's satisfactory.
Yes, that's fine. I mean, my clerks printed that off. I mean, that's on expedition. When we get there,
It's a very short one, my lord.
well, it might even be shorter because this is the donut, but we'll come to it. Nobody appears to have addressed the jam at all. So we'll come to expedition, but there's a rather glaring omission in relation to expedition, which we'll come to. But there are submissions to be made. That's fine. Yeah. So we'll deal with. That's very helpful on the statement. We'll deal with expedition and stay, and anything else that anybody has once we've dealt with the substance, if that's all right.
Yes, of course, Mark.
Okay.
That's what we were anticipating.
All right. So in that case, can we go to, can I ask some questions arising out of the substantive appeal? Now, Mr. Stewart, this is a general point. When you sought permission from Mrs. Justice O'Farrell, that was obviously then wrapped up in her consequentials judgment.
That's correct.
And amongst other things, she said, and I quote, that the appeal was, quote, an attempt to relitigate each and every substantive issue in the case by reopening every adverse finding, obviously adverse finding to the applicants. On the face of it, that seemed to be correct as a description of the appeal. Do you accept that?
No.
So what part of the case below isn't the subject of the appeal?
Well, my lord, there are parts of the judgment which were accepted. Perhaps the most important one comes in relation to the whole approach to the construction of the ICA. Below, there was a vigorous debate as to whether or not the ICA should be construed against the backdrop of the software directive as an aspect of the lex specialis concerning protection for intellectual copyright. The judge found in our favour in relation to that. She found that the ICA was to be construed against that backdrop.
Yeah.
And that is therefore a quite major point, which is in our favour, and unsurprisingly, we're not appealing it.
All right. Well, that doesn't deal with reopening every adverse finding, because that's not an adverse finding.
No, my lord. But insofar as then where it went from there, what we say that she then did was effectively completely misunderstand the backdrop to the software directive.
Well, I follow that, but what I'm trying to get is a part of the case.
Oh, I see, my lord.
That is not the subject.
No,
of
well,
the
Lord,
appeal.
I'm sorry, I misunderstood. We are seeking to overturn the judge's findings in a cascade of different ways, starting obviously with the findings of breach, going through the findings of procurement and conspiracy, both dependent upon the findings of breach. They obviously fall away, but we also have a case that, if, as it were, the substantive elements of breach go, but there are particular elements of the breach which remain, we would say that the procurement and conspiracy go, and there are independent grounds which go to procurement and conspiracy. We've got a separate point in relation to 1.11.4, which is the contractual limitation provision. That in turn cascades down what we would say a series of increasingly unlikely possibilities whereby the judge imported the requirements of section 32 to the contractual limitation clause. She then found deliberate concealment and so forth. We say that isn't applicable, but we also say there were no grounds for doing so. And when it comes to attribution of knowledge, which is the stage of that, we say that she was wrong not to attribute the knowledge of Mr. Anzani to IBM UK. And well, we also, as your lordship knows, have independent grounds in relation to the relief which was granted. Obviously, that is tied up, as your lordship has just observed, with the relief which was granted, and that is of some particular relevance to the question of a stay in due course, but that we can deal with that.
So the short answer to my question is yes.
It is.
Every part of the case is subject to being reopened on appeal.
Yes. Well, what we're not reopening, to be absolutely plain, is the facts in relation to each breach. And
Well, we'll come to that because, with respect, I don't think that's right. There are lots of references to the judge's findings of fact being wrong and unsupportable.
well, we can go through those.
We won't go through all of them, but we might look at one as an example. But I just don't. We need to kill that canard straight away. I mean, everything is an issue, and wrong and unsupportable are by reference to findings of fact. So it isn't right to say that this is a case where it's just principle.
Well, I disagree with that. And it's quite important that I do identify why that is the case.
Well, we're not going to be dealing with this at a high level as if it's a Cambridge debating society. We're going to be looking at the 35 or some of the 35 grounds of appeal, so we can tie them to particular points. So we will have an opportunity to do that then. On that point, there are 35 grounds of appeal in the grounds, but actually that's misleading because many of them contain 4, 5, 6 separate disputes. I think I did an exercise. Ground 5 contained 6 separate complaints. Ground 14 contained 5 separate complaints. I totted them up. There are over 100 separate complaints. If you add in all the further, the judge was wrong too. Further, the judge was wrong too. And so not only is it effectively the case being reopened, but in 8 years here, I've never seen, it's about 10 times more than any grounds of appeal I've ever seen. I mean, I mean, maybe I've been fortunate, but I mean, it's an enormous number of grounds of appeal because everything is an issue.
Lord, in one sense, you're right. In another sense, your lordship is completely wrong. And I think I do need to address you as to why you're completely wrong in probably no more than 5 minutes in relation
to 100 grounds of appeal.
On the 100 grounds of appeal as to why your lordship is wrong to see those, because what you have actually got, you had, remember, 51 breaches in relation to this particular matter. Those were grouped below in a way which isn't entirely easy to follow. 11 of those breaches were either abandoned or found not to exist. So you're left with 40 breaches. Those 40 breaches contain a large number of common points where the judge expressed herself slightly differently in relation to key underlying points. But those key underlying points recur over and over again. And once one has understood those key underlying points, the other matters follow. Because of necessity, some of those grounds have individual points as well. There are particular aspects which go to individual grounds. So, for example, ground 1 and ground 2 unfortunately happen to be outliers. They're individual particular matters. You then get a series of grounds which are all to do with compiler listings, which raise particular points. You get a series of grounds in relation to macros and copybooks, which relate other grounds. And then there are transfer allegations. And the overall point in relation to this is that what we seek to do in the grounds is to explain why the judge's overall approach is wrong. And that is contained really within grounds 1 to 4. We then apply those in relation to the construction points at grounds 7 and following. But if we are right about grounds 1 to 4, and the essence of this appeal is that we are right for reasons I can explain quite shortly, then those other grounds.
Explained it over 80 pages, which is over 3 times as long as you're permitted, so you don't need to explain it again. We have an understanding of those grounds, but it's not limited.
No, my lord.
It isn't limited to those. It's not as if to say the judge was wrong as a matter of principle in relation to the software directive, take a particular element of the software directive, and as a result, blah, blah, blah. And that's not how this is done.
It's not only how it's done, my lord.
Well,
It
isn't. It's not how it's done. So as a result, actually, when you look at it, and I've spent many, many hours on it, you don't get to the point where, oh, well, the answer to that has already been dealt with. There's a bit of that. I quite accept there's a bit of that, but not actually that much. It's surprising how often you have to find a new point which has not arisen before.
my lord, the reason for that, I mean, I've got my own, as it were, checklist in relation to this, which identifies what points go where in relation to the various grounds. The answer in relation to it is that if one looks at grounds 1 to 4, and we are right on grounds 1 to 4, we would say that all save one of the breaches found, and that happens to be ground 1, fall away for reasons which I can identify.
So you would be happy if this application was limited to ground 1s to 4?
No, my lord, of course I wouldn't, because we have independent grounds as to why other matters are wrong.
Well, that's my point.
But my lord,
That's my point, and that's the real issue here. It isn't just ground 1 to 4.
No, my lord, I haven't been saying that it is ground 1 4. What I am saying is, frankly, it's not as bad as it looks.
It may depend from where you are looking at it from, but anyway, there it is.
Well, my lord,
I mean, I understand the point about grounds 1 to 4, but the point about looking at this as an overall application is that I understand you say if you're right about, I know, ground 3, say, well, you say that has big knock-on consequences. I understand that. But if you're wrong about ground 3, you would say, well, that doesn't matter because you've got all your other points. So they all then still are in play.
well, my lord, the answer to that is they're not all in play for all of them. And as I say, there is a checklist in relation to where we are in relation to them. But it's fair to say.
So do I have the checklist?
My lord, you haven't got the checklist.
No, I have to deal with the application as it's made.
I accept that.
All right. Well, anyway.
Sorry, my lord, I didn't interrupt. You have actually got the version from which the checklist is taken, because within the grounds and the skeleton argument are how the thing interplays. But I accept you haven't got a visual representation, which would have been helpful to my lord.
But take for example, ground 3. There's nothing in the grounds of appeal to say if ground 3 fails, then A, B, and C fall away.
No, that's right.
Because they don't fall away.
So that's
because
right.
Because even if you're wrong about the software directive, you have other points about the construction of the ICA, and then you have other points about the items of breach that were found.
Well, that is right. But having said that, we do make the fundamental point that the key aspect of this judgment, which where the judge, we say, goes wrong, is in relation to her conclusions right at the start of the substantive judgment, where she is dealing with the applicable legal principles, where she starts at page 240 on 211, and she then goes through and cites the relevant authorities which she puts forward, all of this in the context, and then she gets to three key paragraphs at 258 to 260.
Well, I've come to those. That's going to be my third question. I'm still on my first. All right. So anyway, well, I think we've identified that point. Before looking, the other general question I had before looking at the individual grounds, and we'll come back to 258 and so on, is this. There is a suggestion that even if we thought that the grounds had no real prospect of success, there was some other compelling reason to grant permission.
Yes.
That was very unclear to me. What's the other compelling reason in circumstances where this is a contract between IBM and Winsopia?
The starting point is that some other compelling reason is the judge's statements, which start at 258 and 260, which are of said to be general application to copyright programs and so forth, and which we say are simply wrong. That's the
That's not a compelling reason.
Well,
because just to remind you, this is a compelling reason if we thought there wasn't a real prospect of success.
Well,
I mean, that's when compelling reason becomes relevant, and this is a judgment in a private law case about a particular contract, and I'm bound to say it didn't strike me as being of any great significance or wider importance at all.
Well, Lord, can I respectfully suggest you're wrong about that? IBM have consistently said, and have said again in their respondent's note for today, that this is only a breach of contract case, that they have abjured any right to copyright protection, and that this case is being brought purely in contract, and it affects only Winsopia as the other participant to the contract, and LzLabs and Mr. Moores as procurers and conspirers in relation to that breach of contract, and therefore purely private law rights. What they are doing is suing under a copyright license, where on the copyright license they say that the copyright is owned either by IBM Corporation or by others, and they are therefore a licensee of that copyright which is provided to, in this case, Winsopia. And they identify 15 programs which are passed over. What they then do by reason of these private law rights, the key right being in relation to the requirement not to reverse engineer any IBM program subject to applicable law, is persuade the judge that they are entitled to protection in relation to matters which are manifestly not copyrightable. And they extend that protection to, we say, particularly to the product of computer programs, that's the outputs of computer programs, rather than to the inputs to them. They extend that to interfaces when that's not copyrightable. And those matters therefore mean that in the future no one's going to bother to sue in copyright because they've got a workaround where they go off to the TCC, persuade a judge, we say, quite wrongly about the limits of copyright protection, and then obtain off the back of that an injunction of extraordinary width in relation to private law rights, which wouldn't be obtainable had the matter been put in the first place. Now, my lord, that, we say, is an extraordinary matter of general public importance.
And you get all this from 258 to 260?
Sorry?
You get all this from 258 to 260?
The starting point is 258 to 260, yes.
That's what you say, the principles you say the judge was wrong about.
Well, that's in relation to breach. Can I just identify the other ones? Because we have picked them out in our general skeleton argument.
Yeah, no, I'm just focus on the question. This is some other compelling reason.
I know.
You just expanded on something that's in the grounds, but this all turns on the judge's construction of the ICA.
Well, my lord, I've made my submissions in relation to that first point, which is the point about the implications of the judge's right in relation to what she said.
Yeah,
because effectively,
but what she's saying is in relation to the ICA, because that's what matters, because this was a case about breach.
Well, it was, my lord.
I understand the point that says, well, you've got to have regard to wider elements of copyright, and your point about, well, is this seeking then to make you liable for something that is not copyrightable? I understand that, but that's ultimately where it comes from.
Well, can I just? This is an IBM standard form license agreement.
Yes, I understand that.
It's applicable to thousands of IBM licensees worldwide.
There aren't any interveners, though.
Well, not at this stage, my lord.
No. Well, it took 33 days. It presumably got a certain amount of publicity in the world that is interested in software. Anyway, on the compelling...
Can I just finish the principles upon which the software industry operates are by relation to licensing agreements. And to say on the one hand, this is only about this private contract and ignore actually the language of the relevant provisions and the background to it.
Well, you can't say that the judge ignored the language. You may say she got it wrong, but to say that she ignored the language just can't be right.
Well,
there's 1,200 paragraphs, one way or another, about the language.
Well, I respectfully don't agree with that. The actual paragraphs that matter in relation to that are very limited. But, Lord, I've made that point already.
Yeah, okay.
Can I just make the other point, though, my lord? You asked about general public importance on the basis that things are wrong. You will have identified that in relation to procurement and unlawful conspiracy, we draw attention to the effectively the mens rea, if I can put it that, which is relevant to that, and in the light in particular of the tension between the judgments of the House of Lords in OBG and Allen, and the statements of Lord Leggett more recently, and in relation to racing partnerships. There are important points left open there. The important points go really to this. The judge had a situation where the evidence before her was that there was a vast amount of money spent setting up an operation in Switzerland and in England, which was subject to the provisions of the Software Directive. And the obvious explanation for doing that was that it was thought that that provided protection. There is also the point
The
that,
judge rejected that.
well, but that's my
Judge rejected that on the facts.
well, my lord,
She rejected that on the facts. She said quite clearly that they didn't have that belief
well, but my lord, why did she say they didn't have that belief?
because that was the evidence before
Well,
her.
my lord, why did she say they didn't have that belief? She said that they had not produced evidence of the legal advice that they had been provided with in relation to that. Now, my lord, I'm summarising the points in relation to that, but that of itself is an important ground in relation to all of this. My lord, can I also make the points in relation to that, that what was said in relation to...
But this is we're still on some other compelling reason.
Well, we're on some other compelling reason, because...
And as I say, reminding ourselves that that's only relevant if the court concluded that there was no real prospect of success of the grounds, but would grant permission anyway.
Well, Lord, I take your lordship's point that if, as it were, you accept that the underlying basis of what's being put there is satisfactory, then that is. But the point.
I mean, that's not your fault. That's, I think, a conceptual difficulty with the some other compelling reason, and it's often trotted out. But actually, I think it means where something is, clearly some vital point of often public law that needs to be clarified. So it's not your fault, but we have to remind ourselves that it only becomes some other compelling reason if the court has concluded actually these grounds of appeal don't have any real prospect of success.
Well,
so really the point comes back to the ICA being a standard form.
well, that's the first ground, and a standard form for IBM, obviously, but also this is the construction of a software agreement which will be looked at extremely carefully by others within the software industry. And just to make the obvious point, software is extremely important in relation to the economy of this country, in relation to the economy of Europe, and the ability to prevent people from taking steps to provide competition. And I'm going to say that, well, this isn't a competition case, but the ability to do that is a delicate balance, which is reflected in public policy in the software directive as adopted in this country. And this case, in our submission, completely upsets that balance.
Yeah, well, I understand that underlying submission. Well, shall we look at, as I say, we don't have time to look at all of them, but let's look at ground one. And the criticism is set out at some length in the grounds. But I think it's 25 to 40 odd in the grounds. I'll just find it. Yeah. Now, in relation to the grounds of appeal, the first point is about the idea expression dichotomy, which I understand to be an element of copyright principle. The difficulty that I have with this one, and it's true of a number, but let's take this one as an example. The grounds identify paragraph 258, which is the one we just looked at, of the judgment.
Yes, Bob.
Copyright protection extends to expression of the programme, but not to ideas and principles underlying functionality of the programme, is the point.
Yeah.
And the complaint is that is an incomplete oversimplification.
My lord, it's not an incomplete oversimplification. If you look at
I've quoted that from the grounds.
well, my lord, it's
Is that not right?
It's much more than that. If you look at the sentence,
So do you abjure what you said?
Lord, I don't object. I don't abjure. It is true that copyright protection does not.
What I'm trying to do is to tether these early grounds to the judgment, which is an extremely difficult task. Because it's not readily apparent where they come from. And so that was something I could hold to, because it was said 258 is an incomplete oversimplification.
Lord, it is an incomplete oversimplification. It's a very important incomplete oversimplification. Would your lordship give me 2 minutes on it?
No, just on 258.
Yes.
Where do you say what it should have said?
Sorry, where do I say what it should have said?
Yeah.
What it should have said in relation to 258 is the key error is that the judge.
Where do you say what it should have said?
It's paragraph 26.
Paragraph 26. If you look at paragraph 26, my lord, of our skeleton argument. Sorry, paragraph 26.
26 of the skeleton.
Of the skeleton.
Yeah, that's the incomplete oversimplification. And then it says the error is illustrated by, and then there are a number of subsequent references.
Exactly.
What I want to know is what you say would not have been an incomplete oversimplification.
My lord, what would not have been an incomplete
Now,
oversimplification?
where do I find that? In this kit, there's 80 pages. I've already made the point, I won't make the point again, but repeat, that's 3 times more than you're permitted to say. Usually when somebody says, this statement of principle is wrong, what it should have said was X, where do I find X?
If you look at paragraph 32, which flows on from 31, what we say there is that anything falling short of reproduction of the text of a program's code inherently cannot relate to the expression of the program. And if one wants support for that proposition in the light of what's being put forward, it is plain that the respondents fully understand that, because if you look at
No, I'm just getting your case.
well,
So you say anything falling short of reproduction of the text of a program's code inherently cannot relate to the expression of the program.
and my lord,
So
where the judge went wrong in
so
essence,
that, well, you say that's what she should have found at 258. That's why 258 is an incomplete oversimplification.
well, my lord, yes, it is. In essence, she's completely right to say that functionality is not protectable, but so are an awful lot of other things which aren't protectable. And when you go through, you see that what she's done is constantly refer to functionality as being the limits of what is protectable, and that is the key error in relation to this. And following on from that, in relation to grounds 2 and 3, and in particular,
I'm using ground 1 as an example of
and so on.
one of the difficulties with the application that so often in these early grounds, not so much later, but in these early grounds, it's not tethered to the judgment. As I say, the bit that's tethered to the judgment is tethered to 258, which immediately gave rise to the question, well, what do you say the judge should have said that would not have been an incomplete oversimplification? I mean, you have to remember, Mr. Stewart, we get 8-9 files relating to a 33-day trial. We are entitled, I think, to have a bit of help as to what the particular points are and why it said the judge was wrong.
Of course.
And with respect, we haven't had that. Hence the questions. We understand that this is bitterly fought litigation. We understand that every point's at issue, but the court needs help, particularly if you're asking the court's indulgence, which any application for permission to appeal does, particularly stays, expedition, and all the rest of it. So forgive my slightly tough tone, but it is something that does need to be borne in mind.
But Lord, tough tone is absolutely fine. I'm not in difficulty with that. What I do need to emphasise is the importance of ground 1 in relation to 258, because the key error here...
Well, that's about the 4th time you've used the expression key error in relation to a number of different things. But I understand, don't get me wrong, we completely understand that grounds 1 to 3, possibly grounds 1 to 6, are the in some ways the most important points, but hence the need for tethering it to the judgment and endeavouring to explain why what it was that was wrong and what the consequence of the error was. So that's the simple point. Okay, so that's an answer then to my question on ground 1.
It is.
Yeah, okay. As I say, we don't have time to go through all the grounds, but I am going to ask you a question about ground 4, because if ground 1 is representative of 1 to 3, 4 may be representative of 3 to 6. Now, the question on ground 4 is this. This is about Article 5.3 and the observing, studying, testing, and so on. Now, the case here concerned disassembly, decompilation, translation. And at trial, the applicant's case was that they were permitted to do that as a result of Article 5.3. And the judge said no, because the judge found that what you were doing was disassembling, decompilation, translation.
No.
So, well, that was the case below. So what I wondered was how this case was open to you now to say, well, actually, all we were doing was observing, studying, testing.
Well, the premise of your question is, with respect, wrong. The key, sorry, I've used that again. The most important breach which the claimant relied on is a 4.13a, which is to be found in tab 15 of the bundle at page 594.
Yeah, the disassembly.
Well, yes, but can I just take you to that because the wording is important. And with respect, my lord, you misremembered it, which is very easy to do. The
Sorry, page
594.
594.
Yes. This clause is reverse assemble, reverse compile, otherwise translate, or reverse engineer the ICA program unless expressly permitted by applicable law without the possibility of contractual waiver. So that's the relevant contractual provision.
Yeah.
Which is now, contrary to what your lordship said, the overwhelming majority of allegations in relation to this were in relation to reverse engineering. And the reverse compilation, otherwise translate, and so forth, were a very limited application. So the important, or predominant purpose here is in relation to reverse engineering.
Which the judge found.
Which the judge found, but that was why I was quibbling, because
Okay.
they are technical terms and they mean different things.
So the judge found in the majority of these cases that was what was happening.
Reverse engineering.
Yeah.
And just to be clear, reverse engineering the ICA program.
Yes. Yeah. Which is a defined term.
Which is a defined term, my lord.
And
But-
so I go back to the question, in those circumstances, since that's what she found the applicants were doing as a matter of fact, where does Article 5, how does Article 5.3 come in? Because she was not finding that they were observing, studying or testing.
Well, my lord, for this reason, the expressly permitted by applicable law without the possibility of contractual waiver, she accepts is a reference to what I refer to as the lex specialis of the software directive. She construes the clause against it. And in respect, that must be right when one looks at it. So you've got a clause here.
My question assumed that.
Yes, Paul. You've got a clause here which has to be read together. What does this mean? What does reverse assemble mean? What does reverse engineer? And what does the ICA program mean? Now, the observation, study and testing is referred to in the software directive, right at the...
It's Article 5.3.
Well, it's Article 5.3, but it's more than that. In one looks at the software directive as a whole.
Right, well,
Okay.
so be it. But the point in ground 4 is Article 5.3.
It is, my lord.
And so the question is, given that she found that what you were doing was reverse engineering, my question is, how can Article 5.3 be relevant?
Because she's reverse engineering. It's a verb which has got to have an object. You're reverse engineering the ICA program, and she finds that the ICA program, which is being reverse engineered, is in various parts. The interfaces, not protectable. The objects, the output of programs, not protectable. So that she, for example, finds in relation to this, that if you run a IBM compiler, and for these purposes, my lord, you can take an IBM compiler to be the equivalent of a dictionary which translates English into German. If you run that on a customer's own program, so as to be able to put it through into an IBM source, then the output of that becomes, she says, equivalent to observe, studying and testing the IBM program. That's the case in relation to compiler listings. Now, that fundamentally means that you have taken something which is the customer's application, you've run it through a purely functional machine, a translator, which will give you the same output every time you put it. It's not something with human creativity or human choice within it. And you will get, on the other side, something which now the customer himself or herself is not allowed to examine, not allowed to observe, study and test. And he's not allowed to do that. And that's the function, that's what she says has happened as a result of the errors that she has made. And so coming back to your lordship's question in relation to ground 4, when one looks at the erroneously narrow interpretation of 5.3.
Well, that's an expression that appears throughout,
What, sorry, Mark?
erroneously narrow, because that's the basis of much of the case
Well,
that says it was erroneously narrow.
can I?
My question was terribly specific. So one last time, since she found that what was happening as a matter of fact was reverse engineering, Article 5.3 on the face of it isn't relevant. So you have to go to the what she found, and then you have to say that, well, although she found that was what was happening as a matter of fact, in some way, had she had some other principles in mind, she would have come to different views on the facts.
My Lord, no, absolutely not.
Well, she found you were reverse engineering.
My Lord, finding you reverse engineering means nothing without an object. It's like saying
Okay,
that,
reverse engineering the ICA
absolutely.
programme as defined in the ICA,
Yes.
programme or partial.
Yes, my Lord, can I just try and put this very simply? Article 5.3 doesn't preclude reverse engineering as such.
It doesn't permit it.
No. It's
So that's the point.
Well,
it's
well,
only what it permits.
Well, we say it is intended to permit and guarantee the right to observe, study and test without the possibility of contractual waiver. And there was no finding anywhere relevant that there was no observing, studying and testing in relation to, for example, the compiler listings. And if it's within Article 5.3, it can't be a breach because it's permitted by 4.1.3, and if that's wrong, it's void.
Yeah.
And
I understand that.
well, but when one then looks at it and says the judge found that what she did, and one sees this at 61 of our skeleton argument, is that she was persuaded by my learned friends that this was in some way an exception and therefore was to be narrowly construed. That's directly contrary to what has actually been said elsewhere. But more to the point, it's simply not consistent with the software directive. This isn't a case where you have a narrow exception, as she seems to think in 5.3. You've actually got a guarantee of rights within the software directive as a whole. And by narrowly construing it, she effectively construes it out of existence.
Yeah, okay, well, I understand that submission. All right, well, that was...
I mean, InfoPack, my lord, which is the decision she relies on, has got nothing to do with software protection.
Well, there's a debate about that, but of course, one of the underlying points is this case isn't as concerned with copyright protection as the applicants now say. Anyway, that's a matter.
It is a copyright license.
So that will do on those. Let me just yes, I'll take one example of the construction of the ICA. So we let's take ground 7. Now the point here is, or certainly one of the main points, there are a variety of points, but one of the main points that you take is that you say that this should have been the subject of what is described in the skeleton as a minimum threshold of substantiality.
That's one of the points we made.
Yeah. Where does that come from?
We say that it comes as a matter of construction. Can I just anchor
Construction of
the clause which is being here?
which clause is that?
Well, it's essentially, my lord, it's not the only breach which is relied on, but it essentially comes back to 4.1.3a because it comes back on this to what is meant by the ICA programme.
But that's a defined term,
Well, that is a defined term, but when you go to the definition,
which includes partial.
well, it does include partial, but if you look, if one stands back from this and says, what is this contract doing? The answer is that this contract is licensing IBM software. And that license is necessary in order that the software can be operated and so forth lawfully. And the 15 programs are there set out. What is being said by my learned friends is that you can take that down so that you can get minute fragments, and they are fragments of what was originally IBM code. It hasn't been copied, but it has ended up in other programs, and that causes breaches of this contract to take place. So that, for example, if customer applications are transferred with these minute passes of code within them, which are always intended to be there, that's a breach of this. And so when one comes to minimum parts and one thinks, what's the protection which is being sought here? The protection which is being sought here is in relation to making sure that people don't copy IBM's code. And we didn't do that. We didn't copy it. We didn't, as is the case, do any literal copying. So the judge is saying that without literal copying, and even though it only refers to minute fragments which haven't been copied, nonetheless there is protection granted by this contract. And we say that when you stand back from this and understand the background, that's where, in answer to your lordship's questions, the minimum, I forget the exact words we used, but the minimum
Substantiality.
minimum substantiality. I would observe, my lord.
So this is context.
This is context, but if your lordship would just go to paragraph 93 of our skeleton. We do make the points in 94.1 through to 94.4 as to why we say this is wrong, and they are a cascade of arguments. Outputs is going back to ground 2.
No, I understand that's why you say it's wrong, but you say it's wrong because there's not a minimum threshold of substantiality.
Yes.
And so what I'm testing is where that comes from, and you say that comes from the context.
Yes, and my lord, just if you look at clause 1.3, which is on page, if you look at clause 1.3, which is definitions, which is on page 579, and you go through the ICA, the definition of program, and the program, the following includes the original and all whole or partial copies.
Sorry, where are you reading from?
Sorry, I'm taking you to the definition which your lordship reminded me of.
Yeah,
In relation, which is page 580, my lord.
Yeah.
And the way it goes is ICA program means an IBM program under license for, and then program at the bottom is the key one.
Yeah.
The following including the original. I'm just taking you to that.
Yeah.
And the point that in the context of partial copy, the following including the original or whole or partial copies must mean substantial parts.
Okay, that's that one. Thank you very much.
My lord, ultimately, that comes from the Act, the English Act, but
That comes
from the English Act.
what, the substantiality?
Well, the substantial.
So I thought you said it was context.
It is context, my lord. But,
So is it from the statute now? You say?
Well, what I'm saying is that when one looks at what partial copies means, and that's where this comes from, that has a minimum requirement of a
So
substantial.
where do I find the minimum requirement?
Well,
You said it was context. Do you now say it's in the statute?
well, Lord, in order for there to be a breach of any copyright, there has to be a minimum level of copying. That can sometimes be quite small, but it is still a minimum level of copying.
Okay. Yes, one of the other grounds in relation to construction, ground 8. Again, there's a complaint that the judge had regard to expert evidence about what was meant by reverse engineering and the like.
Probably not one of our better points.
Well, my understanding is both sides had expert evidence on what was meant by that sort of thing. In fact, both sides, I would have thought entirely reasonably, had expert evidence on a number of these issues. If I had been the judge, I would have needed that expert evidence.
Well, my lord, can I just...
And probably needed it in rather greater amounts than Mrs. Justice O'Farrell.
Well, my lord, can I just anchor this in 121, because this is the short point that we've got in relation to 121. It's on 997. The judge's construction...
Nine.
Sorry, my lord. It's I'm looking at our skeleton argument.
Yeah.
Paragraph 121 on page 97.
Right.
Which I think is the
Yeah,
passage your lordship
I
is-
was asking, the complaint is about the judge relying on expert evidence.
Well, yes, my lord, what she did was that she perceived the experts to agree the terms, but she found there wasn't any standard expert evidence. Our complaint is simply that in those circumstances, it's not a technical term upon which the court may receive evidence from the experts. That's the sum total of our complaint in relation to this point.
All right. Well,
Did the judge rely on expert evidence in saying what reverse engineering meant?
Well, my lord, if you look at 210 of the judgment, what she's...
Well, she says they're not defined terms, they haven't identified any standard definition, and then she talks at a high level of generality. There appear to be various things that they agree on.
That's right.
Okay.
okay. All right.
And the key aspects of our complaint here comes back in 120.1, but it's a point the lordships may fairly say we've already made, which is the failure to have regard to literal copying. But that's a point, as I say, that your lordships may say we've already made.
Yeah. Well, the literal copying point bleeds through a number of these grounds. But there are as I say, we could decide that against you, and you could say, well, it doesn't matter because I've got the points about errors of law or relying on expert evidence or whatever it is. Yeah, okay. All right. Also, final one on the construction, ground 12, which is the time bar.
Yeah.
We obviously have to approach this on the application of the time bar in this case. The judge found that there had been unlawful procurement, unlawful means conspiracy. Now, we put to one side, appreciate you say I'm entitled for permission to appeal on those, but at the moment that's the position on the
Of course.
facts.
Yes.
Now those findings related to LzLabs and Mr. Moore's.
They did.
And so the point that arises that I frankly was a bit baffled by was how those entities, as strangers to the contract, could rely on clause 111(4).
Well, my lord, the answer to that is, first of all, could you have open, please, the relevant words of 111.4, which are at page 587 of tab 15. And Your Lordship knows this is the second half of the clause, which starts on 586. So I wouldn't want to say that the critical words at the top of 587.
Yeah.
And this is an IBM standard contract, and it has two operative provisions. First, unless otherwise required by applicable law without the possibility of contractual waiver or limitation, neither party, so that refers to, in this case, IBM UK, will bring a legal action, regardless of form, arising out of or related to this agreement, or any transaction under it more than 2 years after the cause of action arose.
Yeah.
Winsopia, we said, has a legitimate interest in enforcing that as the contractual party to it. The level of requirement for a legitimate interest is low, and we've cited the authorities in relation to that in our skeleton argument, and therefore that can be enforced by Winsopia. The second part of this clause, and just on the
Winsopia can enforce that.
in order to prevent IBM UK doing what it did in this case, which is bringing a legal action arising out of or related to the agreement. And the reason it's arising out of or related to the agreement is that it is procuring, in one case, is the breach of contract, which it complains of as against Winsopia, or on the other hand, it is entering into unlawful means, the unlawful means being the breaches of contract in the case of the unlawful means conspiracy.
Okay, so the answer to my
Can I
question
just do the
is
second? Can I just do the second?
well, hang on. The answer to the question that they can enforce it on behalf of strangers to the contract is, you say, on a construction of the words.
Yes, but just to make it plain, it's not just the words I read. After such time limits, that's 2 years after the cause of action arose, any legal action arising out of this agreement or any transaction under it, and all respective rights related to any such agreement lapse. Now, those are additional words, and the words lapse in our submission strongly suggest not a barring provision of the sort which one is familiar with in this country in statutory limitation, but an agreement, the rights come to an end of the sort you get in Scotland when you no longer have rights following a substantive period. And those two limbs of IBM standard clause together means there aren't any rights to enforce after the 2 years rises.
Even in relation to what the judge found, which we have to have in mind, an unlawful procurement or unlawful means.
Yes, my lord. I mean,
So if you get away with it for 2 years, you're fine.
well, my lord, there are
Well,
other.
because that's what the judge found. So that's not a glib summary. That must be the position.
Well,
But you say, well, that's simply what the words say. You say.
well, they're simply what the words say, my lord. I'm abjuring the temptation to remind you that was a public launch in March of 2016 that IBM Corporation were looking at the entire position through Mr. Anzani from March 2016 onwards and so forth. And your lordship says those are all matters of fact which go to it, but they are. It is. We would respectfully say your lordship is right. This is an independent point, and I do absolutely make the point that even if the judge is right about this, these words do not contain any kind of statutory section. They are wide and broad words chosen by IBM, and it's a standard form contract contra proferendum. She has somehow implied into these words.
It's the standard words. I understand completely the submission on the words, and that's one of the matters we'll have to consider. I mean, I think, would you accept that contra proferendum on its own isn't your best point?
My lord,
I can't think of a case that's been decided by reference to contra proferendum
my lord,
during your many years, Mr. Stewart, of practice at the bar, some of which overlapped with mine. If you can think of a case that was decided on contra proferendum, then you get a big tick.
my lord, Milena Jr., who says that SAS and WPL1 had a reference in it to contra proferendum.
Well, you've got to get references to it.
But my lord, the reality is that plainly the chances of this case being decided on contra proferentum. Having said that, my lord, if in due course we would strike out, I think it's ground 13, I very much doubt
That anything would turn on it. I follow that.
that's not going to add materially to anyone's burden in relation to this.
No. All right. Well, that's helpful. Thank you very much. Those are those. So then we come to the specific findings of breach, and again, and this goes back to something that we discussed at the outset. Ground 14, the assertions are that the judge's findings were unsupportable is one word, and irrational is the other. And those are words that we find dotted throughout the later grounds. Now, I just wanted to ask you this, and I hope this isn't an unfair question. As you know, in relation to findings of fact, the Supreme Court have said that in order to get home on this sort of ground, you have to say either that there was no evidence, or there was no evidence that a reasonable judge could have, that there was no basis on which a reasonable judge could have reached that finding. Now, are you really suggesting that that is the case here?
Well, ground, yes, is the answer to your lordship's question. And it's a very...
You say about Mrs. Justice O'Farrell and her 1,200 paragraphs.
No, my lord, it's what I'm saying about ground 14, which is what your lordship has asked.
Well, I understand that, but unsupportable and irrational, I'm using this as an example because it comes up throughout these later grounds.
Lord,
I mean, she had the evidence because we've got the passage where she deals with item 1.
my lord, your lordship is, with respect, asking me two questions. Can I answer both of them before you come back?
Yes.
The first is whether or not, in relation to ground ground 14 in relation to item 14, we are saying that the judge's findings fall within the no evidence, no rational ground exception. The answer to that is yes. Are we also saying that in relation to the other aspects where we challenge findings of fact? Yes, but in certain cases, what has been said by my learned friends in relation to that misunderstands what the basis of the factual challenge is. So I hope I've answered both of your lordship's questions. If you want me to briefly...
Basis of the factual challenge?
Sorry, my lord?
You said you referred to misunderstanding the basis of the factual
my
challenge.
learned friends... Sorry, perhaps your lordship hasn't asked me about my learned friends. But on several occasions, we would say that the learned friends misstate what are said to be factual challenges when they're not. That's the only point I'm making. Can I deal very quickly?
This one is. This is what
This is a limited factual challenge to ground 14. And what she has done, in essence, this goes, and it's a point which only goes to item 1, and it is the only point which goes in relation to the error correction. And what she has done, we said, is absolutely plain, that she has misunderstood what it was that the evidence was saying about what the error was. And it's a very simple point. The error which was taking place was on the IBM mainframe, and it was a loop, which meant effectively that a particular operation was taking a ridiculous amount of time. And that error was diagnosed by the exercise which was carried out in relation to IGZ cust. And she has wrongly thought that that relates to the SDM when the error was in the IBM mainframe, and therefore plainly was error correction of the related to error correction of the IBM software. In addition to that, in relation to this specific factual point, she fails to observe that in relation to procurement, because this flows on to procurement to Mr. Moores, he's told about it. He doesn't procure the breach. And therefore, in relation to that, we ask how can it possibly be procurement in relation to it. But that is the ambit of the factual evidence which is looked at. And we say that a judge who understood the differences between what was being put forward to her in relation to the SDM on the one hand and the mainframe, sorry, the software on the mainframe on the other would have realised this fell within that. It's a shorter point as that one.
Okay. And so you do maintain, wherever you say irrational or unsupportable, that it meets the test of no evidence, or one that no reasonable judge could have reached.
Yes, I mean, I'll give you the second example, which is the LDM compiler.
We don't need to have any more examples because you say it applies every time you've used it.
Can I just explain a very limited point in relation to that complaint? The judge wrongly made a finding in relation to the LMD, which I have to say is something which hasn't been used. It's long barred by time if we're right and so forth. It forms no part of the SDM, so it's pretty well at the fringes of this case. But she found that in relation to that, the likelihood was that it had permeated further, and she failed to have regard to the expert evidence, which expressly said there wasn't there. Now, that was probably an error. It's probably easily overlookable. But we say that if you see what was actually expert evidence, and she hasn't explained how that's right, wrong, or anything else. So again, we say that that is a limited error. We are fully cognizant of the limits which, well, I was going to say this court, but as your lordship correctly points out, the Supreme Court has put in relation to factual findings. But bluntly, if even an experienced TCC judge understandably overlooks expert evidence which goes directly contrary to what she's saying and doesn't explain that, then we say that that is justifiably something which this court can put right.
Now, next, a catch-all point for the unlawful procurement and the unlawful means. There are lots of similarities between the two, lots of similarities between the points that are taken. One cornerstone of your case is this question of LzLabs and Mr. Moores believing that the software directive meant that Winsopia couldn't be improved in ICA. I don't follow how that argument could get off the ground in circumstances where the judge found, as a matter of fact, that they didn't have that belief. That was something that we touched on a little earlier this morning. I mean, she expressly finds in her lengthy consideration of this, nearly 100 paragraphs of the judgment is devoted to this, that they didn't have that belief. So I don't understand how this point gets off the ground. I mean, it arises in a number of places. Ground 19 is one of them.
We say that her starting point, and this is at paragraph 884 of the judgment, if I could ask your lordships to turn up paragraph 884. This is the findings of the paragraphs.
Yeah.
884. Fourthly, the software directive arguments rejected by this court would not be sufficient to displace knowledge of the wrongfulness of Winsopia's activities. As explained by Lord Legate, liability doesn't depend on whether the defendant knew that the act done by the wrongdoer was against the law. All that is required is knowledge of the essential facts which make the act unlawful.
Yes.
In this case, the essential facts are knowledge that the terms of the ICA prohibited the acts of reverse engineering and other misuse of ICA programs that LzLabs directed Winsopia to carry out. Now, that we say is fundamentally the wrong starting point.
But that's the point of principle. I'm not asking you about that. I'm asking you about her findings as a matter of fact that they didn't have that belief.
Well, then if we go on to that, if you then look at what she is, Mr. Rockman, this is paragraph 885, is not entitled to rely on any belief that the soft directive would provide a defence to the ICA breaches because he conceded he did not have enough understanding of the software directive. That's just wrong. He didn't make that sub-concession. And my lord, we identify that in our skeleton argument, and that's the foundation of what she's saying.
Which paragraph of the skeleton argument?
If it's at sorry, 189, my lord. All he did was in relation to a specific breach, except that he wasn't an expert. That's the closest you get in relation to this.
Okay, so that
And that is, and if we just to he then, just to be clear, her finding is based on that. Although that would be sufficient to establish the requisite knowledge, I find that Mr. Cresso also had knowledge. And you look at what is being said at a high level. This is quoted at 886. You appreciate the prohibited reverse engineering. And you then look down. Well, that takes you no further than the wrongful finding, we say, on 884, which your lordship properly characterised as the point of principle. So we say that this, it isn't over hundreds of paragraphs. It's a very limited and specific finding, and it's just wrong.
okay. So it's limited. This point's limited to 884 to 886. The error.
Yes, my lord.
Yep.
There's an error in relation to Moores, which we deal with separately, but that's in relation.
Well, there always is in this case, because if you fail on that, then you
Well,
have your next point. I
well,
understand how this litigation works, Mr. Stewart.
well, no,
That's why I'm trying to focus. And generally, you are, with great respect, doing a very good job at answering my specific questions. Not always, but mostly you are.
I'll take that as a compliment.
That's why I have to focus on the nuts and bolts of it.
Well, the only point I'm making is this, that we've looked at LzLabs because they're Rockman and Cresswell. There are similar findings in relation to Moores, which
Fine.
but they're of the same.
Okay, fair point. Fair point. Okay. All right. Now, also in relation to Mr. Moores, you have a ground of appeal, which is ground 23, that Mr. Moores should have been entitled to a defence by reference to the principle in Sade and Butt. And the point that's raised against that is that that was not the argument below, and that's not pleaded, and it would be too late to raise it now.
Right. So it's right, it wasn't argued below. It's right, it wasn't pleaded. It's not too late to take it now because it arises from the judge's findings, which we were hotly disputed, and it is a pure question of law by reference to whether what I would call the side and butt principle, as expanded or explained in the Singapore Court of Appeal in Uliamada, should apply to Mr. Moore.
Okay.
And we say that we fully accept it wasn't taken below, we fully accept that it wasn't pleaded, but we say it's properly open to us on appeal on the basis of the judge's findings, which were contrary to those which we were looking for.
Okay, so for that to be right, that you say that's a pure question of law.
For that to be right, it's got to be a pure question of law.
I understand that. Okay. That deals with those breaches. Yes, small point really, but you say that the judge was wrong to find that there was damage, and she found that there was damage in the latter part of her findings. There's 959 is a paragraph where she indicates that. My instinctual concern about this is that whenever a trial is split into two parts, there is always a potential jagged edge between liability and quantum. The judge's conclusion there at 959, having heard the trial, surely was open to her leaving aside all questions of quantification, which may of course prove on this particular aspect that there was no or very little loss. But the finding that there was likely to be loss was surely open to her after hearing the trial.
Well,
it's a very short bit.
The evidence on this was limited to what Mr. Wallen said, and we say that if you look at what Wallen says, all he does is refer to different forms of damage, which is the type of damage IBM could suffer, and the best example that IBM could give in closing is that Mr. Wallen was involved in multiple calls about the audit letter in January 2021, and they asserted it was self-evident that damage was suffered.
Yeah.
We respectfully suggest that that does not get below the minimum standard. This is a full-time employee of someone. It's not quantified. He doesn't say it in his witness statement, and it's effectively said as a matter of submission that there must have been some damage. That's the point, my lord.
Well, I understand that, but as I say, you can understand my concern. I mean, you will remember that Judge Hicks, for example, was always very aware of this potential difficulty. So he always used, when he ordered a trial on liability, he used to order a trial on liability proper. And of course, if you hadn't appeared in front of him before, you didn't know what he meant. But what he meant was that liability for heads of loss. Now, obviously, that didn't arise here, and there was enough for the judge to deal with and for the parties to argue without getting into that. But I would be a bit anxious about saying, in relation to that, well, because the evidence was minimal, that in some way the judge was wrong. Surely that is a point, subject to all of the other points, best left for the second trial.
Well, my lord, the only other way that this goes in, frankly, is that it does feed in to the injunction grounds in relation to the complaints that we make about the relief which she did give in relation to injunction. Because if the position is that the claimant in this case has suffered no damage or even very minimal damage, the jurisprudential basis for the wide relief which is granted, which is extraordinarily wide, is very thin. That's the interplay which
yeah, but that's a slightly separate.
It is a separate.
Okay. Well, anyway, okay. Well, I understand that. Yes. Next point. This is fun, isn't it?
It's a long time since I've done a Viva, my lord.
Well, I understand that, and I'm sorry that it's taking a bit of time, but that was the purpose of this.
No, of course not.
Hearing.
Sorry,
So,
it wasn't a complaint.
no, I understand that. But
I'm just wondering whether the second examiner's going to chip in.
so the next point is limitation. And I understand the points about, well, you say it was never concealed that LzLabs owed Winsopia, and I understand that Mr. Saunders says, well, fine, but we never had any reason to ask about that until we became suspicious in the summer thing, and I understand that point. What I didn't understand was you refer in your skeleton to Canada Square,
Yes.
and I couldn't quite see the relevance of the windows falling out to this case, but that might be my fault. What was Canada Square telling me that, as it were, I didn't know before?
Well, in relation to this, is if your lordship would just go through, sorry, to
Sorry, it's ground 27,
yes,
and you refer to Canada Square.
Sorry.
199 of the scale. 199 of the scale.
Yes, it's 199 of the skeleton
Yeah.
argument. What we say in relation to this is that if one looks properly at Canada Square,
Can we just do that? I mean, that would be the. I hope any time we need to look at an authority. This
yes, certainly, Canada Square is to be found in the authorities bundle. Authorities bundle. It's at tab 46 on, and that is in the authorities bundle at
Yeah.
volume 3.
Yeah.
And if one looks at what if you look at what Lord Reed says at paragraph 99,
99.
and he starts his analysis in relation to this, but can I take it as read at 96? This is where the relevant passage starts. What the section requires, the defendant has deliberately concealed a fact relevant to the plaintiff's right of action,
Yeah.
and he goes on and sees that. He says in 97, deliberately is laid below, and then 98, he says a duty of disclosure, and then 99, the position seems to me the same as a matter of English, where concealment takes the form of the withholding of information with the intention of keeping it secret. For example, Samuel Pepys concealed the contents of his diary by writing in code. That doesn't imply that he was under an obligation to reveal what he'd written. Someone who decides not to tell anyone that he's been diagnosed with cancer can properly be described as concealing his illness without any implications under obligation. It's been noted that in all the examples I've given, as in most, not all cases where concealed is used in the active mode, concealment involves intentional hiding or withholding information. This underlines the importance of the explicit emphasis on the relevant facts must have been deliberately concealed. And what we say, my lord, is a very simple point. None of the examples in those paragraphs are dealing with a situation where a matter is public knowledge in any event. It is, we say, ridiculous to assert that you're deliberately concealing something which is available on the public registers of companies which are in open jurisdictions,
Okay.
and where the directors, etc. That's the point, my lord.
So that's helpful. So it's 99 of
Yes, I mean 98. Just looking at the words,
Yeah,
use
yeah.
the word "keep secret."
Yeah, 96 to 99, but the summary at 99. That's very helpful. Just,
I mean, it perhaps goes without saying, my lord, that the ambit of that is potentially enormous. If facts which are open and known can be deliberately concealed, then that is very.
Okay. Yes, last one. You have a point under ground 30. This is to do with the audit and the audit request.
Yes.
You have a point that the second letter of January 2021 was not pleaded.
Yes.
And The respondents say it was, and they give a reference. And they also say that in any event, the second letter only really repeated the first letter, which is accepted. It was pleaded. So do you accept it was pleaded,
No.
as the respondent says?
No, I don't know.
So do we have to look at
You'd have to look at the
the
pleading.
pleading? Okay, well, take me to the pleading to say why you say it wasn't pleaded. They rely. This is not the job of the Court of Appeal. I'm being my usual sunny self, but it is not.
Well,
Let's find the passage that is.
the passage is to be found, my lord. in
Paragraph
tab-
38 of the RRRAPOC.
page
Re-amended.
476, my lord.
Sorry, page
Page 476, my lord.
176, thank you.
And it's a very short point, my lord. If you can look at 37 to 38. They rely 37 on the 23rd of December 2020 letter. They abandon reliance on that, and the reason they abandon reliance on that is that it's signed by Anzani, it's signed on IBM Corporation, and it runs directly against the case that they wanted to be put. And as a matter of fact, on the evidence, he received no authority to send that. So they didn't want to have Anzani having authority to
That's not really
send it.
germane to the question I'm asking.
But then, accordingly,
I think that ought to be the last jury point you make.
I'll
So there's the letter at 38.
So that accordingly, by letter of the claimant served notice requiring the second defendant to remedy its breach, failing with which that failing to remedy its breach is the breach which is occasioned by the letter upon which they're not relying. That's not saying this was setting up the audit and so forth. That's the point.
The breach would exist in any event, whatever the letters might have said before or since.
No.
Yes.
No,
Remedy
because-
its breach within 30 days.
But the contractual because the breach being referred to is the refusal to comply with the audit request, which is in 37.
Yeah.
And that has to be that remedying a breach can only be the case if you've already asked it to be dealt with.
Yes.
Well, that's the point.
Right. It's not dripping with the merits, is it?
Well, my lord, your lordship has just abjured me from making jury points, so it's a bit difficult to respond to that. But your lordship might have some regard to the fact that Mr. Anzani's role in relation to this was a matter of some controversy, and there are good reasons why they didn't want the 23rd of December being relied on. But I've already made that point, and your lordship told me not to make.
No.
jury points.
I said it was the last. I didn't say that you couldn't make that point. So you say they didn't like the first letter for good reason. So effectively, second letter, no good without first.
Yeah. I mean, my lord, your lordship
In
has the
simple
point.
terms.
Yes, my lord, you have the point that there are other answers to that point, but that's the answer to the pleading point you've asked me about.
All right. So that's that. Those are the questions that I had. Now, that then leaves, firstly, the question of expedition. Which obviously all presupposes that you get permission to appeal, but since this is the only opportunity we've got for testing some of this stuff, we have to make that assumption for this purpose. Now, I said that it was like a donut without the jam in the middle,
Yes.
but I may have missed the jam. So let me ask you, there are an awful lot of people on your side of the court, and they must have all considered this, and it must be in somewhere. Where do I find in the papers the estimate for how long the appeal will take?
I don't know the answer to that, my lord.
We said 5 days.
We've said five.
I'm very happy for you to turn your back so you
Well,
can
we've
see.
said 5 days somewhere. I'm fairly certain I have because I've given that. But we'll just find out where we've said 5 days.
5 days?
But, well, yes.
With great respect, Mr. Stewart, that's absurd. 5 days? This trial took 33 days. There's no part of it that's not the subject of the appeal. Instead of having live evidence, people will have to rootle through the transcripts. It'll be island hopping of the most extensive kind. I'm afraid 5 days is just not a runner.
My lord, I have thought about this very carefully. I believe that I could properly open this appeal by reference to the grounds, possibly taking advantage, if your lordships were to give permission, to send you a slightly shorter letter rather than the longer letter you have at the moment in relation to some of the key points. Plainly, there would be a renewed skeleton in relation to it. I assume there will be a respondent's notice, at least in relation to the point which I've referred to before as being one of the points below, which is the question as to how you construe the contract against the background of the software directive, but that's not going to add greatly to the matters. I believe that I could open this appeal properly in 2 days. Now, that, therefore, is the basis of the 5-day estimate. One assumes an equal division of time, and one assumes a period of time for reply, and one gives a bit of extra time.
Well, that's why I'd like to see where all this is set out.
Sorry, all of what, the 5 days?
The 5 days and how we get there.
Oh, well, there isn't a how you get there, my lord, but is it not? Well, I'm told that, my lord, the reason why your lordship can't find it is that we can't find it either. But, my lord, I had thought that was before the court, and I apologise, my lord. As your lordship says,
it's the first thing that a listing officer is likely to
I
ask.
appreciate that, my lord. I'm sorry. I'm sorry, my lord. It's plainly it ought to be there. But that's the answer to your lordship's question.
But 2 days to open the appeal,
I should assume
that would be 17 grounds a day.
I don't think I'd probably open it.
I just don't. It's just not realistic.
Well, Lord, I, for my own purposes, put together, against the remote possibility that your lordships might ask me to summarise the appeal, a speaking note summarising the appeal. That note would have taken me an hour to put forward. Now, that note does plainly not cover all the grounds, all the various bits and pieces. But what I am telling your lordship is that once you have got a proper taste of the buffalo, you do not need to eat the whole animal.
Well, the difficulty with that is that because of the cascade point, that isn't right. We do have to grapple with points from very high principle, say ground 1, all the way down to pleading points in relation to some of the things we've just looked at latterly. So it's a complete smorgasbord. And
What you just said depends on whether the first mouthful of buffalo tastes a bit off. If it tastes all right, well, you've got to eat the next one to see whether that's off, and so on.
Yes, my lord, as one carries on eating and the still tastes right, one can anticipate that the pace may speed up. But my lord, there we are. There is another way of looking at this, my lord, which is that, broadly speaking, this divides into points of principle in relation to the software directive and the consequences for construction, which we've discussed briefly this morning. There are then some individual outlier points on one-off breaches, and those one-off breaches are 1, 2, 16 and 49, and they are specific one-off matters where there are not broad points going across. And then there are some actually pretty high-level points about procurement and conspiracy. Your lordship have seen the relevant clause in relation to 1.11.4. I would need to show you the law which supported the proposition that I made about sufficient interest. But 1.11.4 is a version of, please read the words carefully and tell me in what respect they are unclear. That's our submissions in relation to 1.11.4.
well, I understand that.
I'm simply saying, and then one gets to the injunction.
There's no way that this is 5 days. I mean, the reason.
Well, your lordship has a lot more experience than this.
I mean, that's the difficulty. And so all of this stuff about expedition, in one sense, is immaterial, because what matters is whether it is the length of time. I mean, I can say 5 days and you wouldn't get expedition, because if expedition meant this being tried next term, there's no way that the Court of Appeal could accommodate 5 days next term, because most of the lists for next term are done. I mean, they could accommodate a day, that sort of thing. That's why it's so important.
I'm not suggesting this is a day's.
No, and at the moment, at any rate, I just think 5 days is unrealistic. And the problem is that because it's all in, there's no. We have to look at it on the basis of all of these points being in play. All right. Well, that's what I meant by the missing jam in the donut. So you say 5 days. So I'll have to hear from Mr. Saunders in relation to that.
And sorry, just to interrupt, you haven't made a submission. Well, actually, all I need for my appeal are these limited points. Just give me permission on those, and if I win those, then I'll win the appeal. You're unequivocally putting forward all of your points.
I am unequivocally putting forward all of my points, my lord. I do say, obviously, that they are in a cascade, as I think your lordship appreciates, and that if I am right, for example, on grounds 1 to 4, I've already told you that they apply to all on our case, save one of the breaches. If you add grounds 1 to 6,
But that's not accepted. So
No,
that would then be disputed. So
and it's not just that, my lord. The fact of the matter is that we could win on, there's no doubt at all, we could win on some of grounds 1 to 4 and not on others of grounds 1 to 4, which would have consequences and so forth. So I mean, I do, with respect, I'm agreeing with I'm agreeing.
okay. So what else do we need to deal with today, from your perspective, given the rough timetable that I outlined at the
we need
beginning?
we need to deal very briefly, my lord, with why I say expedition, and I take the point about jam is important, and the answer is the American proceedings and the evidence which your lordship has got. I need very briefly to summarise what that evidence shows in relation to that, and we need to deal with quite an important point in relation to what we say is the fundamentally wrong approach of the judge in staying Order 7 of the injunction, but not Orders 4 and 9. Those are the points which are on my list for today.
Okay, well, let me just... So, the American proceedings, these are the ones that are due to be heard at some point next year.
So the evidence in relation to the American proceedings, to be clear, there are now 2 sets of American proceedings. There was only one at the time of the judge. The first set is the proceedings which have been brought in Texas, which have been brought by IBM Corporation against LzLabs, the same defendant as this, and also another Texas company. The evidence in relation to that is that the jury trial in relation to that is likely to take place in late spring or summer of next year. That's the evidence in relation to that. The second set of proceedings, which is the evidence which has come in post the application, is that on the day after our permission to appeal application expedition for stay went in, which is the 15th of May, IBM Corporation launched a series of motions to reopen the Neon litigation.
Mm-hmm.
The evidence in relation to...
Yeah, I've seen that in the what
yes.
I call the red file, the stuff that came in this week. Yeah.
Yes, and on the same day, they also filed a lengthy motion in the existing proceedings seeking discovery as to why the findings of the English court should not bind Mr. Moores in relation to, should not bind LzLabs in relation to the Texas proceedings.
Okay.
And therefore they have signalled an intention. In my own friends' submissions, they say, oh, well, it may be used in the US proceedings. They are doing everything they can. And in the volume, the short volume, with the 474-page exhibit filed yesterday, 225 pages of that is the English judgment, which is exhibited to that. So the short point is that IBM Corporation, the principal beneficiary of the fruits of this action, is seeking to leverage the English action for the purposes of the jury trial next year, and is also bringing separate proceedings against Mr. Moores, seeking to reopen separate proceedings in relation to Mr. Moores based upon the evidence Mr. Moores gave, and where they've exhibited the entirety of Mr. Moores' evidence. They haven't exhibited the judgment in relation to a rejection I made as to the scope of the cross-examination. So that's what that all goes to.
Yeah.
The short point, my lord, for present purposes, is that the American proceedings are seeking to leverage the English action, and they're seeking to do so in two distinct ways, as I've identified.
Yeah.
Mr. Moore's evidence was all given in public, I take it.
Mr. Moore's evidence was all given in public. He was cross-examined about the injunction. He gave evidence denying breaches of the injunction. Mr. Saunders then sought to return to the matter. I objected on the basis it could only go to credit in relation to it. Mr. Saunders made it plain that he was not seeking findings here in relation to that. The judge made it plain that she wasn't permitting any further cross-examination in relation to that, but she allowed exploration of the background of the matter. And that's,
yes. So the evidence is publicly available,
and
if what Mr. Moore said in evidence is relevant to something in the US proceedings, then IBM can presumably use that regardless of the judgment.
Yes, my lord. The obviously the other point, which goes to the Stockwell point, is a different point. And your lordship, I think, has got that. What they're saying in relation to that, you'll see from the own insurance evidence, is not. We're not necessarily saying you are a stop. We've only applied for discovery as to why you shouldn't be a stop.
No, I follow if they're using the judgment for something, but I'm just clarifying.
But
so far as the evidence is concerned, that's available for whatever value it may or may not have in the States.
Yes, and my lord, your lordship, it's also a fair point to say that, as will not be surprising, in the States we are saying that there is no conceivable basis upon which proceedings 10 years ago, which would have been open to bring proceedings on in the intervening 10 years, should be reopened. But that won't surprise your lordship either.
You've got all those arguments, no doubt.
I mean, just to make.
All right. So that's expedition. What?
So that leaves the scope of the injunction, my lord, and this is, we say, really quite an important point in relation to the scope of the injunction. The judge's findings in relation to
just so that we're clear, to start with, what is it that you're asking the court to do?
We're asking the court to stay not merely ground 7, which has already been stayed. If your lordship would just look at the final form of order, which is the sealed order under appeal of a judgment of costs, which is at tab 7 of the
Six is for
oh, sorry, this is my name friend is absolutely right. 6 is the one we want, and it's at page, starts at 1 through 9, but the relevant parts of this, can I just take you to the definition of 1 through 9?
No, I'd like you to tell me what it is you want us to do.
Sorry, we want...
It's always a good thing to start with that.
Sorry, but I thought I'd said it, I apologise. No. We want you, please, to stay not merely paragraph 7, which is already stayed, but paragraph 4, which is a delivery up injunction at page 149, and 142, which is an information deriving from breaches. That's what we want you to do.
So you want us to stay 4 and 6. Which other number?
Yes, I mean 4, 5, and 6 run together because they are together, but it's 4 to 6 and 9.
Right, and that's and you want that pending the hearing of the appeal if you get leave,
Yeah, yes, my lord.
and if you don't, the point doesn't arise.
No, my lord, your lordship has got the points that if we fail on everything else, we have independent and we say very good grounds as to why the injunctions granted in paragraphs 4 to 9 collectively are extraordinarily wide. So if one just focuses at the starting point, we say in relation to injunctions, is to seek to hold the ring insofar as is possible, pending the outcome of an appeal. And obviously, an appeal for which your lordships give leave.
Yeah.
The particular points of difficulty and matters that we ask, we can state really quite.
Well, those are in the ground.
They're actually in our stay. Well, they're in our separate submissions. They're in the separate submissions so far as a stay is concerned.
But the width of the injunction, I thought that was round.
I'm probably confusing it. We've got separate grounds going to the width of the injunction.
Hang on. Grounds 32 to 34 are all concerned with the injunction and the delivery up.
Yes, and those grounds are substantive grounds for the appeal.
Yeah.
And even if we were wrong about everything else, we would rely upon those. The point your lordships have made about, well, it's a smorgasbord.
Well, we've established, Mr. Stewart, you don't need to say that because we've established that even if you fail on X, you rely on A, B, C.
But my lord, the separate point, I'm sure your lordship has got, is that the question for your lordships today is not whether those grounds are right, but whether or not there should be a stay, not only in relation to paragraph 7, which the judge has granted in fairness to her, but also in relation to the other injunctions at 4 to 9.
Yeah, and that is, and that would be pending the appeal.
Yes, of course.
Yeah, because the substantive criticisms of the injunction are at 32 to 34.
Yes, but I mean, sorry, just to make the point completely obvious. I mean, plainly, if we're right about breach, the grounds for the injunction go away and so forth. But I'm simply making the point that when one is looking at how one does justice in relation to this, and that is the starting point on the authorities in relation to injunctive relief, you're meant to be looking at how you can best sort out the position. We say the key error the judge made here was the same error which was made in which I'd like to take you to briefly, which is to stay part of an injunction, but not another part. And when you actually look at the basis upon which injunction should be granted, we say with respect to the judge that there simply can be no doubt at all that she ought to have stayed not merely 7, but 4 to 9 as well. That's the essence of our ground.
The order does, maybe I haven't understood properly, but the order does seem to be a bit contradictory because she hasn't stayed paragraph 7, which on the face of it therefore means that you are free to market your SDM, but paragraph 9 is in force, which prohibits you from offering services, disseminating any information which derives from breaches of the ICA. But the SDM, on the judge's findings, does derive from breaches of the SDA, doesn't it?
Well,
of the ICA.
Certainly, that is what that is what IBM will say. And my lord, one of our points.
So if you do what's permitted by paragraph 7, you run the risk of falling foul of paragraph 9.
Absolutely, my lord.
So you would say it ought to be all or nothing.
We would say it would be all or nothing.
And you say nothing, presumably.
Your lordship has the right to that. And the reason for that is that the judge has accepted in her judgment that not staying 7 would have a destructive, an overwhelming destructive effect on the business. And we say if that arises in relation to paragraph 7, then it arises in relation to paragraph 9 as well. I mean, just criticising number 9 at the moment, just in the context not in the context of the final injunction, but just in the context of what we are meant to do between now and the trial, and looking at, sorry, not trial, the appeal.
If there's an
A
appeal.
Freudian slip, Mr. Stewart.
It was a slip, my lord. I would deny Freudian, but it was certainly a slip.
You've been going to 2 hours, Mr. Stewart, so you're entitled to 1 Freudian slip.
Okay, well, I've used up my allowance. If you look at what it says, using or relying, offering services, disseminate or other, any information which derives from breaches of the ICA. Well, those words, in the context of this dispute, derives from breaches of the ICA, could not be more prone to dispute, frankly. And in this, which has got a penal notice attached to the front of it, and which is continuing in force, the notion that that is something which is of any real benefit to IBM at all, other than to frankly muck us around, pending the appeal, is frankly a nonsense. But my point for present purposes is that it is extremely unclear. If you then look at 4, and just, as it were, take a similar point by 4, each of the first defendants shall by the 16th of July, so coming straight away, instruct Amazon or another interparty agreed by the parties or determined by the court to destroy all copies of any ICA program in their position or control, subject to some exceptions. Now, the definition of ICA program is at 139. Any program in the agreed list of programs licensed as owner next to this order, well, that's fine, that's the 15 programs, including, for the avoidance of doubt, any constituent part thereof. So what that means on the judge's findings is anything down to minuscule parts of code. So they're not merely getting back what they told us, but they're getting back an enormous amount of material, or putting us to a vast amount of expense. And this is all in the evidence. And one then says, for what conceivable benefit can this come to IBM? Well, can I just check you do have our separate submissions in relation to stay, because something that your lordship just said then caused me to doubt that.
I'm sure I do. Which is tab which?
It's in the section 11 of bundle, my lord, and our submissions in relation to the...
Yes, I mean, this is the file I combed through to see where there was an estimate of the length of the appeal.
Yes, well, Lord, I'm sorry about that.
That's right. But it's the
submission signed by Mr. Van Heegen, Mr. Reed. It's written submissions as support of stay pending the appeal, and those submissions run to well, it's 21 pages. That they do, your lordship may say, they say more than needs to be said, but they do set out the essence of what the complaints we make about stay are. The one authority I would like to take you to, if your lordships will permit me, is the decision of this court in relation to HTC and Nokia, because it is a convenient summary of where...
Yes, fine. These don't add to the grounds of appeal.
No.
These are separate submissions in support of the stay pending appeal.
They are.
Yeah, I understand that. That's how I understood that.
Lord, I'm sorry if I gave rise to confusion. But
No. But if you want to take me to Nokia, by all means do.
Lord, Nokia is at tab 36B, is the decision of this court.
Volume.
In volume 2, I hope.
Yes.
And what had happened in relation to this, it was a patent dispute. It was a dispute between HTC Corporation, which marketed a number of different mobile phones, and Nokia, which was seeking to prevent the marketing of those mobile phones. But there was a particular concern in relation to the Christmas period where phones were going to be provided. In November, in a judgment which is just there,
Sorry, give me the tab number.
It's tab 36B, my lord, I hope.
No, I've got 36, and then revolutionary, it goes to 37.
In the best traditions, we've therefore managed
Have,
to
I think they
avoid
just
giving
did.
you the
Either this morning or yesterday. Mine.
Right, okay. My lord has it because that he said it was put in either last night or this morning.
I apologise.
No, that's right. But my clock hasn't got around that. I think my lord. No, don't. We'll share it. How about that?
Well, could I just hand up another copy of the Court of Appeal?
So if you've got
Well, just checking that that's both of them. I want the Court of Appeal judgment, not the. Hang on, that's the first instance judgment. That's the first instance judgment. Lord, what had happened was that shortly before Christmas, on the 3rd of December, Mr. Justice Arnold had considered whether to grant a stay pending appeal. He granted a stay in relation to one mobile phone, which had been marketed for a long period of time, but not in relation to other mobile phones. And he did so essentially upon the basis that by the time those were being marketed, there was the prospect of an action being brought. And in those circumstances, he considered that the judgment would be wrongly, that it would be wrong to stay it pending the appeal. You get the essential facts at paragraphs 2 and 3 on page 933.27. And you then get the well-known principles set out at paragraphs 6 and following, and one sees the critical paragraphs set out by Lord Justice Buckley in Minnesota at the bottom of paragraph 8. The object where it can be fairly achieved must surely be to so to arrange matters that when the appeal comes to be heard, the appellate court may be able to do justice between the parties, whatever the outcome of the appeal may be, and goes on to consider that.
Yeah.
And then refers to Mr. Justice Floyd in Novartis, and one sees the court must be satisfied the appeal has a real prospect of success. If the court is satisfied the real prospect, will not usually be useful to attempt to form a view as to how much stronger the prospects of appeal are, or to attempt to give them weight. Well, of course, that is right. The only point I would make here is that we have got a series of individual grounds going to, for example, the ICA programs, the meaning of ICA programs, which directly impact the relief we're seeking to stay. So if we are right that the ICA programs are not to be broadly construed as they have been done, and we would fail on other grounds, that would be a very good reason for not going forward. We have also got separate grounds, as your lordship knows, in relation to the injunction. I didn't go over that again. Then we see the judge summarising the evidence, and if you then go to the critical paragraphs, you see at 14 that the judge's decision to distinguish between the various forms of phones was a discussion between counsel. And then at 18, Lord Justice Patton is critical of the judge. I consider that his approach to the grant of a stay in this case was wrong in principle. I consider he lost sight of the basis upon which a temporary stay of this kind is conventionally granted. So far as HTC is concerned, there was no clear distinction in the evidence between the effect of the injunction on the one phone as opposed to the entire one range. And although stating the two were not the same, the judge gave no indication that part of his judgment as the facts or otherwise which relied upon to reach that conclusion. And he goes on to make other points as to fact. The evidence has continued to be discussed, and he criticises at the bottom of 19. The focus of the court's inquiries is on the economic consequence to each party of the grant or refusal of the stay. Issues of contingency planning will not in most cases be relevant. They may be relevant to the question of how one should assess the balance of convenience in relation to the grant of an injunction before the trial. By the time of the trial, will either such an injunction in place or have been refused or not applied for. The status quo in those circumstances speaks for itself. And he therefore finds that the whole stay should have been granted. And Lord Justice Floyd said, I'd only add the course taken by the judge appears to me have lost sight of the importance of arranging matters so as to make the doings of justice by the Court of Appeal after judgment on the appeal easier. The partial say seems to be the potential to complicate the subsequent sorting out, whether by way of inquiries to damages or by way of an inquiry on the cross-undertaking of the consequence of judgment of the appeal. For the reasons given by my Lord, I would agree with the order that he proposes. And the Lord, what we then say in relation to the stay can really be very shortly summarised. She failed as a matter of principle to make any assessment of the balance of hardship and convenience in the period before the appeal is heard in relation to 4 to 6 and 9, and in particular to take account of the disruption and other harm caused by paragraphs 4 and 9. She plainly didn't reserve the status quo. The status quo, as your lordship knows, is this has been marketed since March 2016. You've got all of the history going up and so forth. So what is happening now is not the status quo. She failed to consider whether a stay would cause any prejudice at all to IBM. There's no reference at all to any prejudice to IBM or any specific harm versus the irreparable harm which she accepts would be caused by not staying paragraph 7. So the obvious question is, if it's irreparable in relation to 7, how is it not irreparable in relation to 4 to 9? And overall, she failed to consider what course would preserve the ability of this court to achieve justice, whatever the outcomes. And on all of those points...
None of that is any of that really applicable? Because the position is, say we gave permission to appeal, then it would be quite hard for IBM to say that there shouldn't be a stay across the board.
Well, that's the point. If I'm pushing it, that as an open door.
I mean,
then
I'll need to hear Mr. Saunders on that. But
that's my point.
I mean, it's more. What I'm saying is, isn't this more a question of pragmatic order making, as opposed to yet more criticisms of the poor judge?
Well, my lord, I'm happy to violently. I'm happy to violently agree with you in relation.
Well, I mean, this is all being put on yet more criticisms of Mrs. Justice O'Farrell.
Well,
I'd rather jib at that.
Well,
I mean, this is a perfectly straightforward position. If there's a reason why some parts of the injunction would not affect, if permission were granted, the doing of justice by the Court of Appeal, well, that would be a different point, and that would be a matter for Mr. Saunders. But I don't see this, notwithstanding the 21 pages of submissions, I don't see this as further criticisms of Mrs. Justice O'Farrell. It's a question of pragmatism.
Well, I'm very happy not to do that. The point which I'm seeking to meet, and which I think the learned friends do make, is the judge has exercised a discretion in her consequential judgment as to what should and shouldn't be stayed pending an appeal, so that 7 has been stayed until after the final disposal of the appeal on certain terms. And
sorry to interrupt. It may depend, I suppose, on what grounds you get permission to appeal on. I mean, if you get permission to appeal on everything, which is what you want, then that's one scenario we'd have to address. At the other end of the spectrum, I suppose it is possible that we might say we refuse you permission on everything except paragraph 9 does look a bit broad. Derived from breaches of the ICA, which is not even limited to breaches as found in the judgment, which is one of the points you make. Well, we perhaps ought to give you permission just on paragraph 9, and then the question of stay is being looked at on an entirely different scenario, unless Mr. Saunders was prepared to, as it were, make some concession about paragraph 9 in order to avoid having an appeal about it.
Well, Lord, if I may say so, your lordship is of course right, but the door I was pushing at is your lordship is quite right. I get appeal on everything. The point I was making that there is a large amount of points in the grounds which go to aspects of this and which are relevant. For example, the damage point that I explored briefly recently. Secondly, I respectfully agree with my Lord Justice Coulson that it is a pragmatic ground, but when he says, well, you're criticising the judge, I feel I have to, because she is exercising a discretion, and it may well be said that unless that's gone wrong, the court should interfere. That's the limit of it.
Well, there's two separate points. I mean, what we're dealing with here is the stay, assuming we granted permission for some of the grounds, all of the grounds, any of the grounds. But the deriving from point, that is a criticism of the judge, but that's ground 33.
Yes, my lord.
So we need to keep them apart because they are separate things.
They are separate, my lord. It's simply that when one feeds in to the injunction point, inevitably, if you wouldn't get a permanent injunction, you won't get an interim injunction, if I can put it that way. Lord, I'm happy to elaborate the points, but they are in our stay submissions. I can go through them, but each of the 4 headline points I made are rooted in the evidence, and they are set out in the 21 pages.
Yeah, no, I understand
and
that.
I anticipate that at 13 minutes to 1, your lordships are well able to.
So that's the expedition and the stay of the injunction pending appeal.
It is.
Yeah.
Lord, that's me, unless there's anything else I can help the lordships with.
No, I think you've been very helpful.
By help, I mean now,
No,
rather than at some future day.
You have been very helpful. Yeah, okay. Thank you very much, Mr. Stewart. Mr. Saunders, your role is obviously slightly different. You've responded, and I'm very grateful to you and your team for the 20-page response. I think that the fair thing to do would be to allow you to come back on any of the questions that I asked Mr. Stewart, and then to deal with the expedition and the stay.
My lord, I'm grateful. I can be very brief on the questions. I think we only have a very small amount to add to the various specific points that we made in the 20-page document.
Okay, well, just if we do it by reference to, so I've got my notes. I'm doing this color-coded, so you'll need to make clear which ground it is that you're.
Well, I can run through in the order of my lord's questions, if that's convenient.
Fine.
So your first question was, is this the entire case? My lord, it is. The only point my learned friend made was he said there was a very about the point about the ICA agreement being to be construed against the backdrop of the software directive. That wasn't even disputed at trial, and it wasn't. There was no dispute that it was a part of the matrix of fact when one's approaching construction of clause 4.1.3. The question is a factual question: do you get home on those various provisions of the software directive?
And the software directive, as enacted by the Copyright Whatever It Is Act, can, in certain circumstances, override a contract.
Yes, it has a voiding provision. So
Yeah.
the directive itself, and then I can't remember what it is, but some ZA something or other in the Act. It was done by an amendment.
Yeah. So if you have a provision which is contrary to the software directive, then the provision goes.
Well, insofar as it's contrary.
Insofar as it's contrary.
It's not an entire blue pencil.
I understand that, but so it's in an entirely different context. It's a bit like the Unfair Contract Terms Act.
Well, yes. So ACTA would cut through in the same sort of way.
Yeah.
I mean, the question is ultimately, was this an observed study test? Is that what the defendants did?
Yeah.
And my lords have seen in the judgment that they ran that point on every single breach. We cross-examined all their people uphill and down Dale, and the judge made her findings. What she critically found in relation to quite a few of the breaches was it was nothing of the sort. They were disassembling all over the place. So the answer is, one of the difficulties, and this was a point which Lord Justice Mayles asked my own friend about, was there is no alternative position before the court. It is just a morass of high grass. And the number of permutations that arise from this is quite extraordinary when you try and work it through. My Lord Justice Coulson identified 100 odd subgrounds, but actually when you try and work out how the cross-cutting operates, it's quite a difficult exercise. Now, I mean, that obviously feeds into the time estimate on appeal, which I'll address you on in a moment. But it is, we would say, and as you've seen, an attempt at its core to go through and challenge most of the findings of fact, and that's done in the guise of identifying various points in copyright law and approaching this as if it were a copyright claim. Well, it's not. And it was never, critically, it was never said by the defendants that this agreement was void under competition law, or it was void because it was a restraint of trade, because it went further than the IP rights. What happened is the parties entered into a bargain, and part of the consideration offered by the Winsopia for that, for having the license, was that it wouldn't try and hack the software apart, to put it colloquially. So you get the software, you're allowed to use it. That's what they get. They don't get to pull it apart and have a good look. But that is, at its core, what this case is about.
Yeah. Well, I understand.
Marlon, the second question you asked was about, is there another compelling reason?
Yes.
Now, in my submission, my lord's absolutely right to observe that, that's a basis which arises if you haven't got home on the merits test.
Yeah.
Now, there have been cases, things like shared network services, Lord Justice Lewison permitted the occasional cases to go through on that basis, where so often if there's a particular conflict in first instance authorities and it's necessary for the Court of Appeal to decide between.
Well, that's certainly in my experience how I have. I think I've only ever allowed 2 PTAs on that basis, and that was because there were 2 conflicting first instance decisions.
Right, my lord. So it's that kind of thing. And there was another case, 20th Century Fox, where the court said it was a point of general public importance, and the government intervened at that point to try and assess.
I mean, the conceptual difficulty with this second limb is always that you are effectively giving permission for an appeal that you think is hopeless.
Yes,
because it doesn't get over the real prospect of success test. That's why I was asking Mr. Stewart about it, because it always seems to me to be a somewhat limp limb.
It may not be limp when it comes to the administration of justice. If you've got 2 alternative first instance authorities that are causing a problem, sometimes the Court of Appeal will say, well, look, this is something we have to sort out, and this is the vehicle in order to enable that to happen. And I think if you look at the White Book, page 1867, one of the notes explains that Lord Justice Lewison protected the respondent in one of the appeals that went through on this basis because they were doing a public interest job, as it were, rather than.
Well, I say I've given permission to appeal in cases where I thought the judge was pretty clearly right, but I've known that there have been a whole lot of other first instance cases stacking up behind where the insurance industry didn't accept the judge's decision. I mean, a lot of business interruption cases arising out of COVID fell within that category, and it was therefore useful to have a decision of the Court of Appeal which would
ultimately make its way up.
The judge knock them all on the head.
Yes. Yes, and or it's a particular standard form agreement which is used, like the ISDA Master Agreement or something, which is an absolute staple of commerce. But this is not that. This is a private agreement.
Well, Mr. Stewart says it might touch on that because it's a standard form ICA provision, standard IBM contract.
Yes, although it's not. It's a private agreement between IBM and its customers. So this ICA we're concerned with is an English law agreement, which is entered into between IBM UK and UK customers. One of the points elsewhere in the appeal he makes is, for the purposes of Mr. Balls's knowledge, that is different to a US earlier ICA in the Neon litigation, but let's not worry about that for now. There's no evidence that that anyone is concerned with this. I mean, so I think the case, the trial was filed, as my lord assumed, but it's not as if there are follow-on cases and various other customers are coming knocking at the doors and bringing claims or intervening or anything else. This is nothing. It's certainly not on that spectrum at all.
Yeah.
So we say there's no other compelling reason to bring the appeal. The next question, my lord, you asked was in relation to the first ground.
Yeah.
Now, my learned friend said in submissions, anything falling short of reproduction of that program code can't amount to expression. And the effect of that submission is effectively to rewrite or attempt to rewrite the prohibitions, the restrictions in the ICA, in clause 4.1.3, to a very limited subcategory of thing where code is literally copied from one place to another. Now,
Yeah, I mean, that's the literally copying point.
it is, and my lord, that is an extreme way of rewriting an agreement in circumstances where the agreement, as found and construed by the judge, does include the safety net provisions of the software directive already. It is not as if the software directive is not engaged. This is, as it were, a freestanding argument that because of the idea expression dichotomy in copyright law, there should be such a fundamental restriction when you're construing this agreement that it should only apply, this kind of license should only apply in a very, very limited way to direct literal copying. So let's just test that. IBM supply this software in object code. They don't get the source code to most of it. It will no doubt be said, well, the consequence of this is that it is only where that object code is directly copied that the license could be engaged. Well, that's a very restrictive reading indeed of a license, but it's precisely, all it does is effectively do away with the contractual restrictions, which are essentially to prevent one from looking under the hood at the internal operation of the code. And that is, we would submit, entirely consistent with the idea of expressions dichotomy. And just, I mean, it may be convenient just to give you one very trivial example on how observe, study, test works. Imagine I have some software, it's always trouble thinking things on your feet, but imagine you have some software where you run it on your machine, it takes a number as an input, and then it spits out another number. So you type in 10, the number comes out 30. You type in 20, the number comes out 40. You could repeat this process lots of times and deduce that the machine is adding 20. That's what the program is doing. Now, the idea of adding 20 to the input number is something which is difficult to protect in copyright. And it is legitimate to study the operation of the program by operating it in a normal way and repeating that process to deduce, infer yourself what's going on. Now, imagine that the programmer was a rather unusual programmer who wrote his program by taking the input number, converting it into Esperanto, and then doing a manipulation of the input number using the language of Esperanto. That would be a very unusual way of doing this, perhaps, but it's his expression, his free and creative choice as to how he codes that program to achieve that result. What is not legitimate is to hack apart the program and say, gosh, you know, the coder has used Esperanto as the vehicle for performing this particular operation. And that, as it were, is the distinction between the expression, which embodies some of these programmers' choices, and the idea, which is just the idea of adding 20 to the input figure. Now, what we say is illegitimate about some of these these grounds, particularly ground 1, is that what it's doing, in effect, is trying to recast the whole scope of protection and the contractual bargain which Winsopia and IBM entered into. Part of that protection, which is very important commercially for IBM, is that its software is not hacked apart. That is why it is delivered only in object code. It's not given, nowadays, the source code is not supplied. And it's not, that material is kept for IBM's benefit, and it's the result of their investment and so on. So that is why we say fundamentally this is an attempt to recast this away from what was in essence a contract dispute, to try and turn it into not only a copyright dispute, but a very narrow copyright dispute, which is artificially narrow because copyright was never run. You know, if I'd been pleading a copyright case, I never would have run it in the way that it's now being parodied by my learned friends. But it was never the case before the judge. So I'm sorry.
I understand that. The software directive, however, was before the judge.
Yes, absolutely. And so the software directive was there as matrix of fact to the ICA. And there was also no dispute that insofar as it was engaged for specific breaches, it was absolutely legitimate to inquire into whether those provisions were engaged by what had taken place factually. And that is what we see in the judge's very careful judgment, where she goes through and says, well, these are the facts of this particular allegation, this is what was done, I make the following factual findings. This goes beyond observed study test.
Yeah, okay, well, I understand that. Is that a convenient,
My lord, yes, I think.
because that deals with that point. All right, well, we'll come back at 2. I'm sorry that we will be here for a part of the afternoon, but it is useful. Okay, 2 o'clock, thank you.
Alright,